Supreme Court is the Everest so far as the justice delivery system institution as a whole is concerned. But ultimately we have to consider the interest of the society at large. We are not, when we pass the judgment, correct, we are not considering who is in the government, who is in the power. But ultimately, whether it is in the interest of the nation or not, correct, that is why. Conservative means, you see, I am coming from a state or place, correct, where we are we are conservative. We are conservative means conservative. And when you are talking about liberty, correct, one has to consider the liberty, correct, vis-a-vis the national interest.
Your praises or your remarks about the Prime Minister had garnered a lot of social media commentary. Now, there's nothing to suggest that that has in any way affected your judgments, but in hindsight, if you look back, did you at any point regret making those statements?
Why the question of regret? Huh? What wrong I said, correct? My one side is different and judicial side is different. And criticism, we are not, see, as a judge, we are not here to answer each and everything. It is his perception, it is his thinking. Ultimately, you have to act as per your conscience, correct? And I have worked, correct, and perform my duty as per my conscience.
There is so much social media commentary, and it's very often said that you should criticize the judgment but not the judge. But I don't think that line is drawn anywhere right now.
You are absolutely right.
There is so much criticism.
In fact, I am thankful to you for asking this question. That UAPA and PMLA both are in the larger national interest enactment. UAPA is a particular, whoever acts against the interest of the nation, correct, he can be booked and he can be prosecuted under the UAPA.
No, the reason I ask you is because the biggest criticism against the Collegium system is that it's opaque. Nobody knows what is happening and how judges are being appointed.
No, so far as that is concerned, there are so many things which should not be in the public domain at all. It should be within the system itself.
To admirers, he is known as Justice Tiger Shah. And to loved ones, he is known as Mukesh Bhai. But for common people like us, for the past several years, he's been known as Your Lordship. Today, we are honored to have an exclusive conversation with Justice MR Shah of the Supreme Court, who just retired 2 days back. So thank you so much for taking time out and speaking to India today and agreeing to share your thoughts on several issues. Srishti, would you like to take it forward?
So you've been a High Court judge for a long time and you've brought about changes at both the High Courts where you've worked, be it Gujarat High Court or the Patna High Court. What was it like coming to the Supreme Court? And also, did you ever consider staying at High Court and not accepting elevation to the Supreme Court of India?
No, when you see the Supreme Court judgeship is offered, it's ultimately the topmost so far as the judicial institution is concerned. So, whenever somebody enters the High Court as a judge, correct, not his dream, but he would also like that I will be on the Everest. So, Supreme Court is the Everest so far as the justice delivery system institution as a whole is concerned. So, but at the same time, I may tell you that when I joined the bench as High Court judge in 2004, it was never in my mind that someday I will become the Chief Justice or I may go to the Supreme Court. That was never in my mind. Correct. What I considered at the relevant time was I was told that you have to accept it as a service to the society and service to the nation. Correct. So that was the only thing in my mind. And I accepted it as a High Court judgeship. So, when the Supreme Court judgeship was offered, there was no question of saying no. On the contrary, I was the happiest person. And everybody should be the happiest person like me when he is offered the Supreme Court judgeship. Because ultimately, so many are concerned, many persons, it is the dream to come to the Supreme Court.
So, what was your tenure in the Supreme Court? Like almost 5 years.
Approximately 5 years. 4 years and 9 months.
What was the biggest challenge that you faced in the past 5 years? And what was your biggest learning?
there were no challenges. Only thing I have considered the work as worship. And with that in my mind, and ultimately I said in other interviews also and in that speech also, back of the mind always, correct, a common man, correct, and the litigant, poor litigant. Litigant is also a poor litigant, not in terms of money always. But so many circumstances also, maybe a richest man, correct, but when he is dragged in the court proceedings, correct, and his matters are not being taken, correct, there he is a poor litigant. I'm not saying poor man, I'm saying a poor litigant, correct. So it was back of the mind, it was there, and I accepted the challenges. Whatever the work is given to me by the Honorable Chief Justices, respected Honorable Chief Justices, correct, any business, any subject, correct, any workload, correct, I have tried to do justice to those matters.
So, there is a criticism that is often said that you're a very conservative judge in your time in the High Court and in the Supreme Court. That it said, a lot of criticism, blogs also that I read, said that you seem to agree often with state-powered action, any action that is being taken by the state, as against an individual or liberty or any aspects like that. Is this a criticism you agree with?
Not at all. No. Because that criticism, I don't know whether there is such a not. Correct. But it is far from truth. Correct. I have passed so many orders against the governments also. Correct. So many decisions, because some decisions might not have been liked by so many. But ultimately, we have to consider the interest of the society at large. We are not, when we pass the judgment, correct, we are not considering who is in the government, who is in the power. But ultimately, whether it is in the interest of the nation or not, correct, that is why. And by considering that in the interest of nation, correct, if the orders are passed in favor of the government, correct, I should not be criticized, or nobody should be criticized for that. Conservative means, you see, I am coming from a state or place, correct, where we are we are conservative. We are conservative means conservative, correct. So our culture in which I was brought up, is different than other thing. In Gujarat, you see, even single murder is very serious, correct. In many other states, correct, double murder and triple murder, they are routine. So in Gujarat, suppose we say in bail applications, I may tell you, or some other things, correct, that 302, a murder. We are, our mindset is that. So I may refuse the bail also, some may grant the bail also. That does not mean that I am conservative. Correct? That conservative is because of my environment in which I was brought up.
The circumstances.
So the GN Sai Baba case hearing, for example, sir, an urgent hearing was held by Supreme Court in a special sitting. So this, when the Supreme Court has itself time and again through its judgment spoken about the importance of individuals' liberty and also the presumption of innocence. How justified was it for the Supreme Court to hold a special urgent sitting on a Saturday only to reverse an order of liberty? And in addition to that, sir, the case was listed before you by the Chief Justice of India, of course. But were you satisfied that a case for urgency was made out in that particular case?
It's not a question of my satisfaction. Correct. Bench was constituted by the Honorable Chief Justice. Honorable Chief Justice at relevant time, correct, thought it fit that it is an urgent matter. And when you are talking about liberty, correct, one has to consider the liberty, correct, vis-a-vis the national interest. I am not justifying anything. I am not commenting upon the merits of the matter. It is just sub judice before that.
Yeah.
I am on the urgency matter.
Yeah. So
far the bench is concerned, once the bench is constituted and the Honorable Chief Justice constitutes the bench, as an obedient soldier, I have to accept I have to sit in the courtroom. I have no other alternative.
I think you
It was not my satisfaction that there was any urgency or not. I had no choice at all. I had no option.
No, I think you faced a lot of criticism for the order in the GN Sai Baba case, but I believe the Chief Justice had approached other Supreme Court judges before constituting the bench with
You are right.
Is that
And it is not that straightway the bench, particular bench was constituted. After consulting other judges who were available, correct, they might have their, other problems. They might be out of
Prior
country,
commitments.
out of city, some other prior commitment, correct. Thereafter, I was, will you sit? I was not knowing that this is the matter.
you were not aware of
No,
what the
not
case
at all.
was about before the...
So some matter is there, urgent matter. On Saturday, brother saw you have to sit. Okay. And even otherwise, on Saturday, Sunday, even in Gujarat High Court also, correct? I have sat many times and decided the matters. Some urgent matters were there. Correct? Some metro rail project matter was there. It was stuck. Correct? And both the side mentioned, yes, sir, this is a great importance matter, contract matter, tender matter. Correct? And because of the stay order, correct, ultimately our project will be is going to suffer. Then I told, I am ready to sit on Saturday and Sunday also. Because sir, both of them said that we are ready, sir.
No, I think the reason why people say it's unusual is because a lot of time the Supreme Court or any court for that matter is constituted urgently when it's an issue of denial of liberty.
No,
Yeah.
no, no.
But in this case, to reverse an order which had allowed for his release, I think that's the reason why people are not satisfied.
That depends upon somebody's perception, correct? But nothing is true.
But on the urgency aspect, it was not your decision.
It cannot be.
Correct.
It can never be.
It was a decision of the Chief Justice. Sir, you've been a part of many constitutional bench matters. And I know you've said earlier, I've heard in your interview, that the presumption is always in favor of constitutionality whenever there is something that is challenging a constitutional aspect. But even recently, you were part of the Maharashtra verdict and the Delhi government versus LG verdict. So do you think, even though there is a presumption in favor of constitutionality, do you think there are parts of the constitution that might need a relook in the coming times? 10th schedule, for example, that you've dealt extensively with during the Maharashtra crisis case. Do you think there are parts of the constitution that can be reworked? Does our constitution need any sort of amendments or
See, as a
tweaks?
constitutional bench, as a constitutional court, we have to interpret the law and the constitution. We are not here to legislate the law, whether it requires modification, amendment or not. Correct? And we look the constitutional provisions and thereafter we decide the matter, interpret the law, correct? And deliver the judgments. At the most, what we can do is, correct, we can make some suggestion that this would have been better, this would have been better. But if it is palpably, that act is palpably contrary to the constitutional provision, correct, then and then only, in rarest of rare case, it can be struck down.
So, in the past, when you were Chief Justice of the Patna High Court, your praises or your remarks about the Prime Minister had garnered a lot of social media commentary. Now, there's nothing to suggest that that has in any way affected your judgments. But in hindsight, if you look back, did you at any point regret making those statements?
Why is the question of regret? What wrong I said, correct? My one side is different and judicial side is different. Anybody can point out, correct, that because of 1, 2, 3, 4 reasons, correct, it has ultimately affected my decision making on judicial side.
Yeah.
Nobody can. If I have done something wrong, then there is a question of regret.
Correct.
So, do you still stand by what you said though?
Definitely. Standby means what?
Did you still agree with your
I
statement?
think your tenure as the Gujarat High Court judge had coincided during the time when Prime Minister Narendra Modi was the Chief Minister in Gujarat then, right?
Maybe.
Did you have any working relationship with him then? What was it like? I mean, I'm just candidly trying to ask you what is your opinion?
On judicial side, there is no question of working together except
on the
some
administrative
administrative side work is
Correct.
there or some legal services authority work is there. But by the time I was in the legal services authority, correct, I think he became the Honorable Prime Minister. Therefore, and see, as my entire career as a judge, there is no question of any close relation with on political side.
With any executive authority for that matter.
We have to perform our duty as a judge. And I perform my duty as a judge
Correct.
And with emphasis, I can say, with it, without fear, favor, or ill will.
There is nothing on record to suggest in any matter that there has been any sort of influence in any of your cases. I'll 100% say that. But at the same time, I think the reason why there was so much criticism when you praised him
Criticism,
was because,
1 minute, sister. Criticism by whom? Only few.
correct.
Huh?
Obviously.
How many
There is
out
social
of
media
140
commentary.
crores? How many? Correct?
Hmm.
And criticism, we are not, see, as a judge, we are not here to answer each and everything. It is his perception, it is his thinking. Ultimately, you have to act as per your conscience. Correct? And I have worked, correct, and perform my duty as per my conscience. Then why should I worry about criticism from only few persons?
So, but I think what those criticisms are based on, or the reason behind those, is the fact that praises from judicial officers while they're sitting judges about executive functionaries whose case they're supposed to decide might also create a certain perception, public perception
Sister,
regarding
ultimately,
independence of judiciary.
Ultimately, everything depends upon your conscience.
Okay.
As a judge, correct.
As a judge, anybody can point out, correct, that because of whatever it may be, I don't say for a moment, correct, but ultimately, he is there.
What is your opinion of the criticism that judges nowadays face? There is so much social media commentary, and
Yeah.
it's very often said that you should criticize the judgment but not the judge. But I don't think that line is drawn anywhere right now.
You are absolutely right.
There is so much criticism.
In fact, I am thankful to you for asking this question. You should criticize the judgment, but not the judge. Because I said that so far the judge is concerned, correct, he has nothing personal. Correct? Whatever the matter is placed, whatever the constitution, what are the facts, correct, he delivers the judgment. Some person, correct, busybody, correct, or some NGOs, they don't like some particular view or the judgment. They started criticizing. At the same time, those who have nothing to do, correct, they start criticizing without knowing anything. They don't know even the facts also. They are not concerned at all, but just time pass, correct, and just start
Do you
making
like this? Has this ever impacted you? Have you ever felt pressured?
Not at
by
all.
the
No. When I see, I always believe that I am above all these things, and a judge should be, correct, above all. He should
Correct.
not be
Absolutely.
pressurized by any outside forces. His only thing, he should be clear in his conscience. Only thing in his mind is to do justice, and nothing else. Then what is there? How are we concerned with any criticism, pre-judgment or post-judgment?
So one law that you've dealt with quite extensively in a few of your judgments has been the UAPA, where recently you also had given the judgment about how a membership of a banned organization is liable for a criminal offense. So keeping that in mind, do you think the UAPA itself might be prone to certain misuse by the agency because of what's happening on the ground that we see? Do you think that there is any scope of changes to be brought either in the UAPA or even in laws like the PMLA, where it's more difficult for somebody, it's an uphill battle for somebody to try and get some relief for themselves?
See, sister, there are number of judgments of the Supreme Court that abuse or misuse of any provision, you can't declare the law, correct, as unconstitutional. If any particular action or act, correct, is not in accordance with law, it can be challenged before the court of law and it can be struck down. But that cannot be a ground to challenge the constitutionality. You must have seen this. I am not here to support my judgment or views. Whatever is there in the judgment, I am telling. Correct? That UAPA and PMLA both are in the larger national interest
Okay.
enactment. UAPA is a particular whoever acts against the interest of the nation, correct, he can be booked and he can be prosecuted under the UAPA. It is not, reasoning are also given why that particular provision, correct, is not ultra vires. Knowing full well that a particular association is indulging into the activity against the interest of the nation, because everybody, when a citizen of India, correct, its paramount consideration should be first the interest of the nation, national interest issued. Knowing full well that this association is acting against the interest of the nation and is declared as a banned, still you continue the affiliation. What does it suggest?
So, but what happens in cases where the association gets banned later on? For example, PFI, if we take the example of
You have
PFI.
you have not known the provision, that is why you are asking. The provision is he was a member, correct, and has continued to be a member.
Despite it being...
Despite the association is banned. So it is not that in past he was there, he can be punished. Both the things should be there.
So not just UAP, even otherwise recently we have seen political parties claiming that investigating agencies like CBI or ED are capable of, not just capable, are in fact being misused according to them by the government. Do you think that's possible with how the law is? Do you have an opinion on that? Is it possible for the government to use these investigating agencies to maybe stifle dissent in the country?
No. See, that cannot be there. It is the duty of the investigating agency, correct, to unearth the truth. And during that investigation, correct, something, you see, some accused or some persons who are involved, they feel that they are being harassed, go to the court. Within 24 hours from arrest, he will be produced before the magistrate. There are other remedies available. There are other constitutional remedies available. Then there is the question of making any grievance. Ultimately, at every stage, because see, it is the right of the investigating agency to investigate and to make allegations and counter allegation at the threshold when investigation is going on. It will be demoralizing the investigating agency. You have got the remedies available.
Yeah.
Suppose you have not committed an offence, you feel, go to the High Court. Charge sheet is filed, file an application for discharge. There are so many remedies available. But at the threshold, you say, no. And this is, many a times you see, these such allegations are there, so that the investigating agency is demoralized.
So there was also a recent judgment that you had passed regarding default bail and how default bail can be cancelled considering if there are certain, under certain circumstances. And the state has a part to cancel default bail even though charge sheet and all might not be filed. Now I understand that the intent behind that judgment was to reduce the sort of laziness or anything that the investigation agency should not hold back, that they should go ahead and file the judgment. But it is also being criticized as a judgment against individual liberty, because default bail is a right that is given to any accused in case of inaction by the investigating agency. So anything about this judgment that you would like to say on default bail?
So far as the default bail is concerned, it is true that after 60 days or 90 days, an accused has accrued the right. But we are forgetting one thing, that releasing on default bail is not on merits.
Correct.
You have rightly said, because of the inaction or some negligence on the part of the investigating agency, and the investigation doesn't continue more and for a longer time, which may ultimately affect the accused. That judgment which was given on default bail was that if the investigation is already concluded within that time, it was a question of interpretation, not taking away the right. If 60 days and 90 days the charge sheet is not filed, and immediately on that the charge sheet is, the default bail application is made, he has a right to get the bail. So everything depends upon the facts of each case.
Okay.
Once right is there, right is there.
So you're saying it wasn't a general rule, it was specific to that
It was
particular case.
related to particular facts of that case.
Okay. Understood. So, there was a time when you were a High Court judge and your transfer was recommended to the Madhya Pradesh High Court, which eventually did not go through. But from then, now you've been a member of the Supreme Court Collegium itself. As a member of the Collegium, is it ever frustrating when there is so much work that the judges do to send names and the government does not appoint them or sit on them endlessly?
That is not happening frequently or
But
usually.
it's happening in some cases.
Some cases, individual case it may happen. There must be some valid reasons, maybe valid reasons also. But it is you see, individual case to case basis. Correct? Otherwise, the system is working very well between the Collegium, Supreme Court, and the government. And see, by and large, all appointments are made in Supreme Court also, in High Courts also. But many a times on an individual case, it takes some little bit more time because ultimately some IB report, other things, so many other considerations are there which are required to be considered.
But there must be some level of discontentment again amongst the judges, because recently we even saw in the recent Collegium resolutions, the Collegium has put out details about the objections that the centre had regarding certain appointments. They've put out details of the IB and the raw reports. So is this something, because you were part of the Collegium with Justice Chandrachud's tenure, so do you think that this is something that is a welcome move towards greater transparency? Or do you think that it should not be put out in the public domain?
Transparency is okay, but many a times it is.
No, the reason I ask you is because the biggest criticism against the Collegium system is that it's opaque. Nobody knows what is happening and how judges are being appointed.
No, so far as that is concerned, there are so many things which should not be in the public domain at all. Correct? It should be within the system itself. So it is better sometimes it is not disclosed in the interest of that candidate also. We are not concerned with the public or public perception. We have to consider the interest of the institution as a whole. A particular judge is working, suppose he is functioning, is not considered. Correct? And if the reasons are given, it will affect, correct? He is working in the High Court because he is still continued. That is the reason.
Are you in favor of the Collegium system? Do you think it's a well-oiled machine? It's working well?
So long as a better system is not coming, the present system is working very well. But in every system, maybe this Collegium system or any other system, correct? There are always possibility of something better. But that does not mean that present system is bad.
So what changes do you think we can bring about in the Collegium system to make it better?
It's working very well. Only thing, the communication many times between the government and there should be open discussion.
Okay.
So, but
in-house open discussion.
Okay.
So, with government not clearing the recommendations that are made by the Collegium, what we've also seen is the judges who are involved, the judges whose names have been recommended, have often been on the receiving end of several speculations or criticisms. Like even in your case, when the transfer did not go through, there were speculations and claims that the same was happening because of your alleged proximity to the ruling party then. So do you think it's fair to the judges involved in question? How did you deal with those speculations back
It's
then?
not happening at all. There is no question of it. There may be some delay for some consultation process is going on, some other inquiry, means IB must be going on, correct?
Yeah.
And some might be there in the mind of government, some equal, representation, all these things. Government is also a part of the system. But ultimately, everything is going on well. Correct?
Yeah. So do you think, as far as post-retirement jobs are concerned, do you think it's okay? Do you agree that it's okay for judges to take up post-retirement jobs? Or do you think there should be a cooling off period right after they retire as judges?
Very, 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 personal, question is asked. Therefore, I would not like to answer that at this stage. But I may tell only one thing, that if a judge has worked for 19 years continuously, day and night,
Yeah.
correct? Thereafter, because 62 or 65 is nothing at present. And you got the experience, you are healthy, correct? You worked for all these things, correct? Why not to take any assignment, correct?
Yeah.
But it maybe you take some rest and thereafter accept it. And nothing wrong in it, accepting it. Otherwise, if that is so, correct? So many tribunals will not function. Most of the time, tribunals, judicial officers are required. Judicial members are there.
Yeah.
ITAT, NCLT, DRT, CAT, take any NGT. That if judges after retirement will not accept, what will happen to those
Do you
tribunals?
think if we raise the retirement age for the judges, judges will be less keen on taking up post-retirement jobs? Because if, like you said, I think I've heard in an earlier interview, you said that the retirement age should be at least 70. Because there is so much judges have to offer. Many judges who come to Supreme Court work for a year or two, after that they retire. And that is majority judges who don't even get enough time. You got 5 years. So do you think raising the retirement age is a solution to a lot of problems?
Definitely.
Also, the fact that the retirement age for High Court and Supreme Court judges are different.
See, that difference, there may be different retirement age in High Court and Supreme Court, nothing wrong in it. But in both the places, it should be enhanced. Because you will be having a experienced person's
Benefit of the experience.
benefit of the experience, which the judges earn. Judicial officer functioning as a High Court judge, he has got, or the judge who is appointed from the bar, correct, or the High Court judge, Supreme Court judge, after working for 5 years or 3 years or 6 years, and earlier 12, 15 years as a High Court judge, you will be losing an experienced person.
Correct.
And
So
you are dearth of you are not getting good judges also.
So you've seen the Supreme Court during a tenure of 5 different Chief Justices, from Justice Gogoi to now
Justice
CJI Chandrachud. Who, in your opinion, I mean, either whose tenure did you enjoy working as a Supreme Court judge the most, or who do you think has had the maximum impact on how the Supreme Court's functioning today?
No, all the chief justices were very kind to me. They gave whatever the work is allotted to me. I have done it, completed it. Justice Lalit and Chief Justice Lalit and Justice Chandrachud tenure. I also dispose of so many matters on taxation sides, commercial litigation, arbitration matters, and other on criminal side also. Because of so many matters pending here, similar matters in the High Court and the other places were stuck. All Chief Justices were kind enough to me, and because all of them were knowing, that is what I believe, that I am a workaholic judge. Whatever the
Court
work
of
is,
no adjournment, I believe you called it.
correct.
Yours
I was
was
a court of no adjournment,
adjournment.
and only a thing was court of no adjournment, but with a patience hearing. Nobody should feel that I was not properly heard. You see.
So, whose tenure out of the 5 CJIs, if you had to pick one, would you say was the most impactful as far as the Supreme Court is concerned?
On the administrative side,
On the
not
administrative
on the judicial side.
No, I was not concerned with the administrative at all. So I had
No impact on the Supreme Court that the tenures have had in
everybody
terms
has
of that.
performed very well. All the honorable Chief Justices.
Okay, so just a last couple of questions before we wrap up. In your tenure as a judge in the High Court and the Supreme Court, which was the most difficult case that you had to give a judgment in? That you felt very unsure about, that you don't know whether this was the right judgment or not? The most difficult case for you to decide? Anything that comes to mind?
No. Fortunately for me, and by the grace of God, correct, all the cases came before me. I tried to solve it within 4 corners of law. But most difficult, one case was there. I said that 6 persons were given death sentence. Their SLVs were different. And thereafter review allowed, dismissed, and thereafter it came before us. Justice Sikri, Justice Nazir and myself bench. I came here in 2018, and the entire matter was reopened. And ultimately, I felt, and the bench also felt, that it is a case of acquittal. So at that time, there was some, you see, I was in double mind, because once SLP was dismissed and thereafter, but we ultimately consider, you can tell all others that were saying that right to liberty, that all
It
the
was overturned.
all the 6 persons were acquitted.
In the Supreme Court, yes.
So that was MR Shah,
Yes,
who
sir.
considered the right to liberty. Not only that, in exercise the powers under 142, we awarded 5 lakhs compensation because they were coming from tribal community.
Yeah.
And one person was suffering from psychological problem while he was in jail. So that perception changes from matter to matter.
Right. And so, just last question: how did this name Tiger Shah come into being? How were you given the title of Tiger Shah? We want to know the story behind it.
That was love and affection of Honorable Chief Justice Chandrachud towards me. And he started since like 2-3 years. And we went to, I think it started when we went to Russia in some conference. From there he said, and all throughout, he said कि tiger कोई भी काम tiger को दे देगा, tiger कर देगा. So that is how he started. But it is his sheer love and affection and respect for me.
So you've been part of so many benches in your tenure as Supreme Court judge. Any one bench that you would like to pick that you liked being part of the most? That
Or which judge you
being part of the
enjoyed
most?
sitting with the most?
In fact, I enjoyed with everybody. Because my nature is such. I will never be in conflict or confrontation with anybody. On the contrary, I'll try to help as far as possible. And everybody was happy. That मैं कहता था कि मैटर सुना था सर मैं लिखा दूँ that help that okay मुकेश भाई लिखा देगा. So उनका जो some burden correct senior judge का जो था that is come down.
Okay, so then which of the Supreme Court judges and your colleagues would you miss working with the most now?
So it will be injustice to all of them, because
Others will get
angry.
I enjoyed all my colleagues who sat bench with me. I hope so that they also must have enjoyed with my company also.
Yeah.
I enjoyed with everybody. I'm coming from a Gujarat where, correct, our culture is different. Cooperative, down to earth. When I joined the bench, somebody told me, Mukesh bhai, jahan bhi pahuncho, it was not in my mind that I will come, Supreme Court judge, I will come. Kahan bhi pahuncho, down to earth rehna. And I tried to become that. I continued down to earth. I have seen in my entire career that their power has never entered my mind or head.
So, any regrets from the past?
No regret.
No regrets.
No regret at all. I am parting with full satisfaction that I have done my work. In my account, 714 reportable judgments.
Is 714 the correct number?
714 or 712. Correct number. And approximately more than 1,200 total judgments I have delivered. That can only be done. No, he is a Supreme Court judge. In High Court, I have disposed of number of matters. So I have no regret. I am going with full satisfaction, but only one regret.
What's that?
If I have got some more time, I would be able to serve the nation and the country and the institution as a whole.
Perfect. Thank you so much, sir, for taking time out, speaking to India Today. That was Justice MR Shah, exclusive on India Today, 2 days after his retirement from the top court of the country, after serving almost 5 years as a judge of the Supreme Court of India. With Srishti Ojha, this is Nalini Sharma signing off for India Today in New Delhi.